Good morning, everyone. I'll be discussing another tried and true topic. This is reasonable accommodations. Probably a set of buzzwords you all have heard before. I don't have any, up and coming or recent developments, but because this issue is recurrent, it's evergreen, we felt it would be good to give an overview, a primer on it today. I'll be covering generally three laws as they apply to you as Massachusetts employers. You have the ADA, Chapter 151B, which is Massachusetts law, and then the Pregnant Workers Fairness Act, which has a federal and Massachusetts counterpart. There may be other laws, as has been said earlier. If you operate in other states, other laws to pay attention to, that state's laws. But because most of you operate in Massachusetts primarily, we'll be focusing there. So when it comes to reasonable accommodations, there's really three steps to consider. The first is the individual legally disabled, as that term is defined under the ADA in Chapter 151B. Step two is, has the employee requested an accommodation, or do they appear to need an accommodation? Are they regarded as needing an accommodation? We'll get into that. And then step three is the requested accommodation, if they brought up a specific one, or if you're working through different accommodations to deal with, is that accommodation reasonable? And all three of these steps are things to consider as you're working through the process, and each one can be outcome determinative. And what I mean by that is, if step one, is the individual legally disabled? If the answer is no, then steps 2 and 3 don't apply. Step 2, has the employee requested an accommodation, or do they need an accommodation for some other means? If the answer is no, then you don't have to get into the question of whether that accommodation is reasonable, because there won't be one. So the first step deals with disability. An employee under the ADA and 151B, though it uses the term handicap. An employee is disabled where they have a physical or mental impairment that substantially limits a major life activity. And it's not just whether they have an impairment, currently at that point in time, but whether they have a record of having an impairment or are regarded, so perceived, considered by you as having an impairment. All three of those categories bring with them the legal protections of the laws that I'll be talking about today. As far as what a major life activity is, and this is a non-limiting list, but it includes things like walking, seeing, hearing, learning, speaking, performing manual tasks, the things you do as a human being on a day-to-day basis. And depending on the particular job that someone is performing, these impairments can run the gamut. So you have mobility issues. If you have stairs in your building, going up and down stairs, sitting down for long periods of time. If someone drives for long hours, night blindness can sometimes affect them. Intellectual disabilities, mood disorders, or even just medical conditions like diabetes, MS, even cancer, all of those things can fall within an impairment depending on how it impacts the particular employee. And it is safe to assume that someone who has a medical condition and substantially impairs their life, their activities, is likely to be disabled. And so if that happens, you should begin to consider whether and how reasonable accommodations come into the picture. So what is a reasonable accommodation? It's an adjustment or modification that enables a disabled person to perform the essential functions of their job. And just like there's a wide range of impairments, there are a wide range of accommodations that can be implemented. Physically modifying a workstation, so standing desks, as opposed to just sitting in one place stationary all day long. Modifying a schedule, again, I mentioned night blindness, so adjusting the hours to account for that condition. Modifying when or how a particular task is performed. Light duty is another option, which you may have heard of, so shifting work within the person's job that's less physically or mentally demanding than their usual activities. And then time off or leave is sometimes part of the equation as well. Once you become aware that an employee is or has become disabled, you should consider whether a reasonable accommodation is required. And this can happen when an employee comes to you and volunteers that information, or again, if you begin to regard them as disabled, or if you learn they have a record of being disabled. But I do want to focus on the first of these because it's a common question, right? An employee that you have comes to you, brings a disability to your attention, and they request a specific reasonable accommodation for their condition. Do you have to give that reasonable accommodation? The answer, it depends. Like everything in the legal field, it depends on whether the requested accommodation is reasonable. What is a reasonable accommodation? It's one that does not create an undue hardship for you as the employer. And these undue hardships can be a variety of different things. It can be financial, so if the accommodation costs too much money. If it's operational, it affects the efficiency of the workplace, or creating a threat to the health or safety of that employee or others. One way to work through whether or not an undue hardship is implicated is to have an interactive dialogue with the employee, and in fact, it's required to have this open and an ongoing conversation with the employees, sometimes the employees' medical providers as well, to figure out what is going to work best for them and for you as an employer. And the best recommendation is to be flexible and creative with how to problem solve for that employee. I mentioned leave or time off. This is often an appropriate, reasonable accommodation depending on the disability that you're dealing with. And if you decide to give it as a reasonable accommodation, it can overlap or extend other entitlements to leave that the employee may have, whether that be under your company's policies or the state and federal laws that apply. So we're talking sick time, FMLA, PFMLA, other medical leaves of absence. When deciding whether or not time off works as a reasonable accommodation, you should check your handbook, company policies, make sure you know what is provided for, as well as whether any laws come into play. And of course, if you have any questions, we're always around to answer them. But as far as what's reasonable for time off, the only real rule of thumb is that an indefinite period of time off is not reasonable. Now, you can have a certain period of time where they come back and they maybe bring a doctor's note that has a re-examination. They say, I need an additional period of time. That can be reasonable. But in determining what type of length you're okay to offer, you can absorb, you should consider whether that employee's role can be temporarily replaced or whether their responsibilities can be shifted to or shared by others. These are factors that you can consider in determining not only whether time off works for you as a reasonable accommodation and for the employee, but also how long that time off will be. But time off as a reasonable accommodation in and of itself doesn't need to be paid. However, your policies and other state and federal laws, as I've mentioned, may require payment or allow payment. So again, PFMLA, short-term disability, long-term disability, depending on your policies, workers' comp, these are different pieces to think about. And while they won't be accruing time off during the leave as a benefit because they're not actively employed in they're not actively doing work, they're still employees of the company, right? This is leave with job restoration when they return. So they're still entitled to health coverage as long as it's handled just the same as if they were in the office working, and maybe other benefits depending on your policies, insurance, retirement, pension, all of those can come into play. Just very briefly about individuals who are applying to jobs and not currently employed. The requirement to provide a reasonable accommodation can still come up in this situation. So if you have a job applicant that has a disability, as I've talked about today, and falls within that definition and requires a reasonable accommodation, you need to have that dialogue with them. So different examples of this can include things like if you have a job applicant who is blind, providing an application to them in Braille. If you have a job applicant who again has mobility issues and your office is located on the second floor, well, consider whether or not you can do a virtual interview with the person, or maybe meet on the ground level or at a nearby location that is on the ground level. And again, just to briefly touch on this because it's not the main topic at issue, but the Pregnant Workers Fairness Act carries with it reasonable accommodation requirements as well that may come into play. As I mentioned, there is both now a federal and Massachusetts counterpart, and you should be aware of both. Those who fall under these laws may require reasonable accommodations just as with disabled employees, but this time it's for a pregnancy or childbirth-related medical condition. Now, what are those? Morning sickness, gestational diabetes, hypertension, or carpal tunnel that may be caused by the pregnancy, lactation or expressing breast milk, which may continue after the birth for a period of time, and also up to issues of recovering from a miscarriage or even postpartum depression. All of these can implicate the Pregnant Workers Fairness Act. You've got the same undue hardship standard that's in play and the same interactive dialogue that you would go through for a disabled employee. But there's a key difference as far as state and federal law is concerned here. When you're dealing with the Massachusetts law, which applies to any employer that has 6 or more employees in Massachusetts, it's the same sort of accommodation is only required, or reasonable accommodation is only required if the employee can still perform the essential job functions of their role. However, when it comes to the federal law, which applies to any employer that has 15 or more employees, they don't have to still be performing their essential job functions in order for the protections to kick in. Under the federal law, if the employee has a temporary inability to perform, or no accommodation could enable them to perform for a period of time, as long as they can perform in the near future, they can be temporarily excused from performance under those circumstances. So it's just a key distinction to maintain awareness of. Now, another one of the big questions surrounding this topic is, okay, I've given a reasonable accommodation. Now, how long do I have to keep it in place? And again, I hate to use the word, but it does depend. It depends on you as an employer and what you can absorb, what you can handle. It depends on the employee and their specific requirements, the disability condition that they're dealing with. But you should plan to accommodate until either there is no longer a condition that needs to be accommodated, or until the accommodation begins to create that undue hardship. And even if you begin to approach that undue hardship or think you may be entering that territory, you should try and keep up the dialogue with the employee, continue to evaluate the situation, and see how you can work with them. And remember, it's okay to involve the employee's medical provider, or to ask the employee to provide some documentation, especially if you harbor a doubt that the disability is continuing for whatever reason, or you need additional information to help the employee navigate their duties and responsibilities. But it can get complicated as these continue to carry on. So again, if you have any questions, we're only a phone call away.
At what point can I ask for that documentation, or the proof, if you will?
Yeah, I would say that if this wouldn't necessarily apply to your situation, but if the disability is pretty evident, right? Then asking for or requiring you could be, opening yourself up to some issues there. But if you have any doubt, or even if you just it's under the I need more information in order to provide you what you may need, or to understand what you're dealing with and how it affects the workplace, it's certainly permissible to ask for or require a doctor's note in that situation. And if the employee refuses to provide it, then that may give you the ability to not grant the request if you so choose, or to offer a different request that doesn't match what they've specifically asked for.
Great. How do these accommodations work for paternity leave?
Paternity leave?
Yes.
So it's kind of so that's one of the ways in which maybe you don't need to give a reasonable accommodation necessarily because they're already covered under the PFMLA that may apply to them, or even the FMLA for an extended period of time with no pay but job restoration. So in that situation, the individual is not dealing with, a disability. They're just going to take care of a child. So the PFMLA would kick in for them. But if you've got an employee that falls within the Pregnant Workers Fairness Act, if they need an extended period of time off as a result of pregnancy-related conditions or complications, then you could consider whether or not that time off would be reasonable accommodation, or whether there's some other way that you could make it work.
Question about light duty. If you want people to light duty and they kind of say, well, I need to always be at light duty, is there a way out of that?
I think at that point you could involve their medical providers. There's also independent medical examinations, or IMEs is another way that you could do it. So if you want to get someone who's neutral to examine and determine what the disability-related needs are, I certainly think the longer, maybe not right away, but the longer it goes on, and the more it seems like the employee is not in good faith participating in this interactive dialogue with you, the closer to requiring that or considering that as an option.